everybody. Welcome. Thank you for being here tonight. And I've got some, hopefully y'all can hear me. I am not in my office, so I don't have my microphone, my lighting, all that kind of stuff. Working out of a hotel room right now. And but this is something that I think is very important, and I wanted to get out there about qualified immunity. I think this is going to be groundbreaking. I think this is something that is going to make a huge difference in really destroying this fiction called qualified immunity. And many of you know that one of the goals of mine when I went to law school was essentially to chip away so much at qualified immunity that it becomes almost useless because there's just nothing left of it. And in order to do that, you've got to take cases to their appellate process and get a court to recognize, okay, well, there wasn't any on-point case law before about this. Now there is, and now the next time it gets chipped away at, kind of like how Turner v. Driver did with filming. This is how this all started, and I'm not gonna, because I want to talk to Jim, or with Jim, not so slim Jim, who's in the chat room there. I want to do a podcast with him, really about a lot of the particulars. But what really started my deep dive into qualified immunity was last week, or Tuesday, I guess, this past Tuesday, I think it was. The Fifth Circuit panel that heard our case against Olmos Park affirmed qualified immunity for the Valenciano and all those other people, and it really, really pissed me off. And so I started doing this deep dive, and I talked to our attorney Brandon, and he found this case as well. But as I started doing this deep dive, it occurred to me that this is kind of how the system works. I was not an activist until law enforcement turned me into an activist. I was just a guy trying to go about my life. I mean, I was on orders back when I got arrested in 2013. I was on orders to go and take over as the commandant of the Military Intelligence Academy out at Fort Huachuca, Arizona. And probably would have spent another 5 years or so in the military, but for that arrest. And what that arrest did was it turned, just a guy who was just trying to live his life into an activist, a gun rights activist. And then, of course, there were 2 more arrests after that, and then the tasing in Olmos Park. And that's what led me to decide to go to law school. I never wanted to be a lawyer. That wasn't something that was ever in my trajectory. Had everything gone the way I wanted it to go, I'd be working in corporate security right now. So, the Fifth Circuit last week, in our case against Olmos Park, decides that it's going to affirm qualified immunity. And I kind of expected that the court was going to affirm qualified immunity because the question was whether or not you have a First and a Second Amendment right simultaneously, and that, officers haven't been put on notice. Apparently a police officer has to be explicitly told that you can exercise more than one right at the same time. And that's what we were trying to do in this case, was essentially tell officers that you cannot, just because someone is armed doesn't mean they don't have a First Amendment right. And just because someone is speaking doesn't mean they can't be armed. Just because someone's protesting means they can't be armed. And that was the whole goal of that, was to try and prove that point. Well, unfortunately, all the court did was just affirm the qualified immunity. They didn't create any new right that should have put officers on notice. So I really started digging into qualified immunity. Now, let me tell you, where does qualified immunity come from? It doesn't exist in the Constitution. It doesn't exist in law. There's no code or section or statute or ordinance or anything that talks about qualified immunity. But the basis of qualified immunity comes way back from English common law. It's a common law defense. What that means is, way back in the day before America was America, we had kings and queens running around in Great Britain, which is kind of where we are from. That's where our system of law comes from. And the system of kings and queens, of course, is based off of this idea of a sovereign who is selected by God. And therefore, because a king or a queen is doing God's bidding, the king cannot be challenged. It's sovereign immunity. The king is the sovereign, and the sovereign can do no wrong. That's where this philosophy comes from ultimately. When the United States departed from Great Britain and we created our system, even in our own Constitution, sovereign immunity was pretty much codified into our Constitution. And I don't want to get into the nitty gritty about all that, but you can look at it right now. Just look at what's going on with Donald Trump and how the arguments, and I'm not going to get into whether those arguments are right or wrong or good or bad or anything, but the argument right now is that because President Trump was president and under the Constitution, he's got immunity. That still comes from this. If you really think about it, it means that our government believes that they're working on behalf of God, that everything that they do is because God is directing them. That's how it used to be with the kings and queens, and our founders created this government and believed in this sovereign, which is the government now instead of one king or one queen. And then, so that's where this sovereign immunity comes from. And as a matter of fact, under our laws and under our Constitution, essentially, you can't sue the government for doing government things, and even if they violate your rights. And thankfully, back in 1871, they understood this. At some point, it took them 100 years just about, but they realized that, we've got to do something about this sovereignty issue. And here's how it happened. As you know, the 13th, 14th, and 15th Amendments were passed in order to, end slavery and recognize that all people, regardless of what they look like, have rights. And unfortunately, after that, the Democrats didn't like it and created these Jim Crow laws, and were treating black people still differently. They're finding ways around the 13th, 14th, and 15th Amendments. And so what Congress ended up doing was passing what they called like the Force Acts, Force, F-O-R-C-E, the Force Acts, not Star Wars related in any way, but it was essentially forcing the Democrats to stop being racist pigs and treat everybody equally, the way that all mankind should be equally. The third Force Act is what is called the Civil Rights Act of 1871. And the Civil Rights Act of 1871 is what would become the modern day Section 1983. So what I want to do, and since I don't have my multiple screens and all that, I don't normally use my laptop for doing sharing and all that kind of stuff. So it's going to be a little weird, but I'm bringing the receipts. The Supreme Court created qualified immunity based on common law defenses. And again, that common law defense is that the sovereign can do no wrong. It was just made up, literally made up out of thin air. And therefore, if you were a police officer or any government official, you had qualified immunity if you were just doing your job, right? And initially it made sense because, the point of qualified immunity, for example, let's say a guy's robbing a bank, and the police show up, and the guy tries to run, and the police are chasing the bank robber, and they tackle him, right? Well, normally that would be assault. When you tackle somebody or prevent them from moving, there's all kinds of things it can be, whether it's assault or false imprisonment, things like that. But because the police are doing their job, apprehending a criminal, they should not. The criminal should not be allowed or the officer should be protected from a criminal suing that police officer for that alleged assault. Now, obviously, if it's excessive force, that's a whole different thing. I'm just talking about the standard common law or even statutory law for assault, false imprisonment, things of that nature. So that makes sense, right? I mean, if a police officer, if your house is being broken into and a police officer has to tackle a guy, or the guy starts shooting at him, and the cop shoots back and hits the guy that's raping your daughter, the guy shouldn't be allowed to sue the cop for defending your daughter, right? Unfortunately, this entire thing of sovereign immunity went way past the intent, and the Supreme Court has created this doctrine that goes way beyond the intent of, I think, initially what qualified immunity was supposed to be, which was protecting cops in the course of their duties. The problem is now it doesn't just protect them in the course of their duties, it just protects them against anything. So what I want to do first here is I want to, and this is going to be really weird because I'm not able to direct StreamYard into just one page. So I'm going to try this here. I'm going to add this, and then I'm going to go here. Oh, wait. Yeah. See, and I can't even look at myself. So this is Section 1983. This is what we have today. This is what the Supreme Court has, when it created qualified immunity, this is what it created qualified immunity from, is 42 USC, so Title 42, United States Code, Section 1983. This is a civil action for deprivation of rights. In order to get around the sovereign immunity, theoretically, under the common law, the only time you can sue government is when government gives you permission to sue it. That's what 1983 is. 1983 is Congress saying, okay, we are giving you, the people, the right to sue the sovereign under these circumstances, right? And these circumstances are deprivation of rights. So every person who, under the color of any statute, ordinance, regulation, custom, or usage of any state or territory or District of Columbia, subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any right, privilege, or immunities secured by the Constitution and laws shall be liable to the party injured in an action at law, suit in equity, or other proper proceedings for redress, except that in an action against a judicial officer for an act or omission taken in such officer's judicial capacity, injunctive relief shall not be granted unless a declaratory decree was violated or declaratory relief was unavailable. Now, I'm not going to get too much into this last part, but what I am going to tell you is that since 1871, when this law was initially passed, there's only been one amendment. And that one amendment to 1983 is right here, except this part right here. And the reason for that is and this, I believe it was in 1996 when this was updated and this amendment was added. And all they did was make it harder for you to sue a judge for doing his job. But it still does provide a very narrow path if you do need to sue a judge. So we're going to keep that out. But I wanted to highlight to you that since 1871, the only amendment that Congress has passed to what we know as 1983, 42 USC 1983, is what I've got highlighted right here, where they essentially made it harder to sue a judge or a justice, okay? That's it. Other than that, everything else here is untouched, theoretically. But I did a deep dive and started looking into, because I'm trying to figure out what is the history of 1983. Well, here's the history. The history is this, and let me go back to this, add this up. This is, 1871. Here we go. Let me get this out of the way. I don't know if y'all can see that or not, but I can. This is what we consider, it's called the Civil Rights Act of 1871. This was passed on April 20th, 1871, and this is the law itself. Now, this might sound familiar, right? Be enacted by the Senate and House of Representatives of the United States of America and Congress assembled. And then here we go. Any person who, under color of law, or any law, statute, ordinance, regulation, custom, or usage of any state shall subject or cause to be subjected any person within the jurisdiction of the United States to the deprivation of any rights, privileges, or immunities secured by the Constitution of the United States shall, any such law, statute, ordinance, regulation, custom, or usage of the state to the contrary notwithstanding, be liable to the party injured in any action by law, suit, or equity, or other proper proceeding for redress, such proceeding to be prosecuted in the several districts. And it talks, this stuff is all codified elsewhere, but it ends essentially right here, proceeding for redress, right? And you notice in the original 1871, you don't see the part about judges, and that was added. That wasn't added until 1996. So you see that, right? You see that. Now I'm gonna bring to your attention something here. I don't know if I can highlight any of this for you. Never mind. Let's just not do that. Let's just not do that. All right. So this is it. Now I want to come back and forth to this. This is what was passed on April 20th, 1871. This is what eventually became 42 USC 1983. Now, what happened was, and here's a little bit more history for you, is that, I turn this off. What used to happen is, yeah, 420. It was passed on 420. Very astute of you, ED4 action. Back in the day, 1871 and prior, everything that was passed by Congress was considered what was called a statute at large. So Congress would pass a law, it became a statute at large. And of course, the only way that anybody knew that there was a law out there was they would have to print it up and distribute it out to the states, who would distribute it out to the cities, who would distribute, probably post it somewhere. I don't know how all that worked back then, but they were called statutes at large. And then Congress realized, my gosh, we've got, and what would happen, let me back up and not get ahead of myself. What would happen is each year or each congressional session, private companies, organizations, individuals would compile all of the laws that were passed. And I bet you the states probably did this as well, would just compile all the laws into a single volume of what was passed that year. I got to try not to be too loud because I don't know how thick these walls are here, and it's 10:30 at night. But and so you'd have these volumes of statutes at large, but they wouldn't be organized. They would only be organized by what was passed. And in one year you might have something passed that deals with commerce and that deals with trade and that deals with immigration and that deals with border disputes or whatever. So these volumes would have all kinds of different things. So the Congress in 1873 and 1874 decided we've got to do something about this. We've got to get all these laws that are all out there. We've got to organize all this stuff. And so they decided to organize everything into what was called the Revised Statutes of the United States, the first revised statutes of the United States. And that's where they took all of the statutes at large, everything that had been passed up to the point of 1873, 1874, and put them into one spot and organized them under titles, different types of titles. I'm going to give you an example of that. I'm going to show you here. This is kind of the statutes, the revised statutes, they called them. The revised statutes of the United States, the first one. And this was done in 1874. And as you can see down here, let me get this a little bit bigger for you. So this is Title 24, and it's titled Civil Rights. So they took all the laws that had to do with civil rights, and then they gave them new numbers, right? So you could go to one place and have civil rights statutes if you wanted to know what civil rights statutes. And then they gave them a new number. So what was the Civil Rights Act of 1871 became Title 24. Whoops. Oh, my goodness. I just skipped. Okay. Became Title 24, Civil Rights, Section 1979. Stop. What are you doing? See, I'd rather have my own computer. This is what happens when I'm on the road. So, and you can see right here where it says 20 April 1871 becomes section 1979. And then you can read here, this is what was passed on April 20th, 1871. Every person who under color of law of any statute, ordinance, regulation, custom, or usage of any state or territory subjects or causes to be subjected, any citizen of the United States or other person within jurisdiction thereof, the deputy, blah, blah, blah. Okay? But wait, is this the April 20th, 1871 law that was passed? And I thought, this looks pretty short. And if you remember, we'll go back to this is kind of a long paragraph. And I realize this is bigger, the font here, but I'm like, this just looks a lot thicker than what we were just looking at. And as you compare them, so then what I did was I printed this out, right? Printed this out. Then I printed this out right here, section 1, and I compared them. And what you're going to notice here, and this is what I can't do. But I want to pay some, this is what was passed, what you're looking at right now on April 20th, 1871. This is what was passed by Congress. And what was passed by Congress includes these 16 words. Any such law, statute, ordinance, regulation, custom, or usage of the state to the contrary notwithstanding. I'm going to read this one more time. I want you to get this into your head. Think about this. Try to memorize it with me. Try to remember. Follow the bouncing ball. Keep this in your mind. This is the law that was passed in 1871. Passed by the House, passed by the Senate, signed into law by the President. Any such law, statute, ordinance, regulation, custom, or usage of the state to the contrary notwithstanding. Those 16 words right there. Any law, statute, ordinance, regulation, custom, or usage of the state to the contrary notwithstanding. What does that mean? What it means in everyday usage is you cannot claim a common law defense. That's what this means. There is no common law defense to this section of the Civil Rights Act. So if you violate someone's rights, they can sue you. And that's it. It doesn't matter what a law says. It doesn't matter what a statute says. It doesn't matter what an ordinance says. It doesn't matter what a regulation says. It doesn't matter what your immunity says or usage of the state, how things were done in the past. To the contrary, notwithstanding, those things don't matter. That's what this means. These things do not matter. Okay? If you violate someone's rights, they can sue you. Don't go hiding behind a common law defense. Well, if you go back to here, remember those 16 words? Oh, stop it. Remember those 16 words? I want you to find, here, let me do this. Oops. Let me do this. Come on. There we go. And let me minimize that a little bit. I'm going to put these side by side. Here we go. That's the original law. This, stop it. There we go. When the compilers, whoever was tasked with compiling all the laws into the first revised statutes of the United States, took this over here, the original law, and enacted it into the code, into section 1979. Now, here's the problem. These two aren't the same thing. There's words missing from section 1979 and 1874. What you will not find and what does not exist is a congressional act that amends section 1979 here. Oh my gosh, it's driving me nuts. That amends section 1979 here. Essentially what amends the Civil Rights Act of 1871. We are missing where Congress said, you don't get qualified immunity. Now, keep in mind, qualified immunity didn't exist back then, but you don't get your common law defenses that you would traditionally have. We are saying people can sue you if you violate their rights. Stop violating their rights. Stop treating black people differently than white people. That's what this was about. That's what this law was about. And if you do violate their rights, don't think you're going to hide behind, oh, well, I'm the sovereign. You can't do that because it says right here, sorry, customs and usage of the states to the contrary don't matter, notwithstanding. This is the new law. You can be sued. So then what happened in the future? Let me turn this off again real quick. 1871 was the Civil Rights Act. And then in 74, they compiled all of these statutes at large, including the Civil Rights Act. And someone, we don't even know who. We don't know who was in charge of transcribing all these laws and organizing them by section. And so we don't even know what laws there might be even laws out there that do even more that we're unaware of because they were never transported over, unless you take the U.S. Code today and you take the revised statutes of yesterday and compare them to every single law passed by Congress since 1776, you are not going to probably be able to even understand that. I mean, you've got to think back then, people are literally in there transcribing every single law and compiling them into this on a typewriter, compiling these things onto a single document. There might be spelling errors and all that kind of stuff. And yes, there were, because there was a second revised statutes of the United States. So, but from 1874, miraculously in 3 years, 16 words disappeared from 1983 in the revised statutes. And then you've got the civil action. You've got when the U.S. Code was created, it took those revised statutes and again changed. So what was the Civil Rights Act of 1871 became Title 24, Section 1979. Title 24, Section 1979 became eventually Title 42, Section 1983, as we know it today. And it was Section 1983 that the Supreme Court had access to when it invented out of thin air this idea of qualified immunity. And the reason they did that is because the Supreme Court could not see those 16 words because they didn't exist. As far as they knew, they're sitting there reading the U.S. Code, and the U.S. Code doesn't say anything that your common law defenses notwithstanding, right? They don't matter anymore. They don't see that. All they see is what you and I see today in Section 1983. Now, as you know, the Supreme Court has also made it very clear that when it comes to interpreting the law, the constitutionality of a law, the courts are required to go by the letter of the law. The letter of the law is how they interpret cases. It's how they interpret different arguments and controversies, is by what does the statute say. And if the statute is silent on something, you can't be charged with it. But if the statute says something and you've done it, you can be charged with it. And if there's a word that's not defined, and of course, you know, in statutes, they define words. If a statute defines a word, you have to use that definition. For example, if there's a statute that says if you make your house too cold, that person can sue you for being too cold. And then you go and you find, well, what does too cold mean? And the legislature has said too cold, in this section, too cold shall mean anything under 51 degrees Fahrenheit. I don't know. I'm just making stuff up, right? So in that particular case, the court would have to say, during trial, they would have to prove that it was at least 51 degrees Fahrenheit or less in order to be charged under that statute that somebody was too cold, that you made somebody too cold. If there is no definition of what is too cold, then the courts have to then Okay, is there a common usage for that term? Obviously, that would be pretty broad, right? Because what's too cold to me as a Texan is probably shorts and bikini weather up in Wisconsin. Not so Slim Jim could probably tell you about that. When it gets down to 60, it's sweater weather for me. But 60 up in Wisconsin is probably summer weather for those people, and in Montana and all that. So the court would probably say, well, the legislature did not define the word too cold, so therefore it's unconstitutionally broad. We can't charge this person because we don't know what does too cold mean. And anyone that's married out there knows that when you're in a bedroom and you're trying to go to bed, too cold means something different to you and your wife. Like, to your wife, too cold is like anything under 70. To me, it's like 50. I don't like, my wife has a million blankets on and I'm burning up. She's freezing cold. So it's unconstitutionally broad. However, in this particular case, it was defined. The legislature did tell the court that qualified immunity doesn't exist. But because the court didn't see that, it had to infer the common law defense of qualified immunity. So what does all of that mean? It means that qualified immunity is dead. Now, I have also, and I'm going to try and find this while I'm talking to you. So I was talking to Brandon, and I was starting to look up, I was trying to find cases, because I'm like, wait a minute, surely since 1874, someone has argued that, hey, wait, Supreme Court, qualified immunity doesn't exist because the act that was passed by the Congress specifically said you don't get qualified immunity. So you guys have made this up, but Congress has said you can't do that. If Congress says you have to turn right, the Supreme Court can't go and say, no, it's okay to turn left here, right? Just like in this case where Congress has said you don't get qualified immunity, that's what those 16 words mean. You don't get qualified immunity. The court can't just say, well, we're going to give you qualified immunity if it's, and this has kind of been bastardized so much that literally cops have been caught stealing money from people, and the courts have given qualified immunity because there's no case law in point that says that officers should have known that it's wrong to steal from people. But from now on, it's wrong to steal from people, right? How stupid and absurd is that? But apparently cops are that stupid and absurd that a court does have to tell them that. And a court gives them qualified immunity when they steal so much money because they hadn't been told before, don't steal money as a cop. There's a case called Rogers v. Jarrett. And this is what's really interesting about this. And I'm going to try and find this really quick because in the Rogers, let me tell you a little bit of history while I'm looking this up. In the Rogers v. Jarrett case, the story behind that. So Rogers is he was an inmate, and he was one of those kind of trusted inmates, right? Where he's given a lot of latitude to work sort of with minimal supervision and all of that. And so he's out there working, he's fixing things, and he's cleaning up around wherever he was cleaning up at. And a portion of the roof collapses and it falls on his head. He's knocked out, right? But I mean, otherwise he's fine. There, no broken bones, thankfully. So visually, Rogers looks fine. Well, when he comes to, he's kind of shaking it off. He's like, man, I don't feel so good, I just don't feel right. And so he goes to the whoever the jailer is. His name's Jarrett, is his last name. And he's like, dude, I don't feel well. He's like, you look fine, get back to work. Stop malingering, get back to work. I think a lot of people in the military understand that. You actually feel bad and the sergeant's like, you look great, get back to work. Rub some sand in it. Drink water. So Rogers goes back to work and it gets worse. He's like, oh my gosh, he's seeing double. His head's spinning, and he goes back and he says, I need to go to the infirmary. I don't feel well. Something's wrong with me. And again, Jarrett says, you're fine. Go back to work. All you've got is a scratch. He's got like a scratch on his arm or something. So, well, he goes back to work. Well, eventually he collapses and his head starts swelling up. His face starts bruising, and they rush him to the hospital. He's got a traumatic brain injury, and he had internal bleeding. So the force of what hit him, while there wasn't any external damage, there was internal damage to his brain. It knocked something loose, and he nearly died. It was excruciatingly painful. He lived. Then he sued. That's how you get the Rogers v. Jarrett case. And of course, as is the case, the courts found that officers had qualified immunity. Look, hey, it's not his fault. The guy looked fine. Yeah, but I told him that I was feeling bad. Man, but he looked fine. And, officers haven't been put on notice that just because you say you don't feel well, that they need to provide you with medical care just because you say you need medical care. So he appealed. Appellate court said, yeah, we affirm qualified immunity. There's no case law that says that just because you say you need to go to the infirmary, that officers have to take you to the infirmary, especially when you look fine. Now, if someone had cut your leg off, just a mere flesh wound, then they'd know that there's something wrong with you because they can see that your leg is missing, right? And then you cut another arm off, and but I've got another arm. Okay, sorry about that. Little bit of Monty Python humor there. But, in those kinds of cases, the court argued, look, this guy looks fine. How's the officer supposed to know? Well, you and I who think normally, well, the officer's supposed to know because the prisoner told him, I don't feel right. Oh, and by the way, he was knocked out. That should have been an indicator that something was wrong. You don't just get knocked out by something unless there's an injury somewhere. But the court affirmed it. So they went up to the Fifth Circuit. Fifth Circuit, this is where it gets interesting. Fifth Circuit said, and I'm going to bring this up for you. This is the Fifth Circuit case. I'm not going to read everything to you because it really doesn't matter. So here's the case if you're looking for it. This is the number here, 419 CV 2330. It's number 21-2200. And this was March 30th of last year. I was like so surprised. I hadn't even heard of this case. And probably because, and I probably read it because I do read Fifth Circuit cases when they come out because I'm always interested in, okay, what can I use in the Fifth Circuit? So I read a lot of boring case law. And this was just another one of those boring case laws that, once again, officers are given qualified immunity. So you can see here, trusted prison inmate, blah, blah, blah. They thought nothing serious had happened. They didn't immediately grant his request. Inmate's condition worsened. He was diagnosed with traumatic brain injury. They gave summary judgment to the defendants for qualified immunity, right? And then for the reasons below, we affirm. So the Fifth Circuit said, sorry, can't do anything about it. Rogers tried to go about his business. He said he was lightheaded. He was drifting in and out of consciousness. You would think a normal person, not a cop, cops aren't normal people. I don't even know if they're people, would think, wait a minute, he's drifting out of if he's drifting out of consciousness, we should probably get him some medical help. But no, they didn't do that. They just kept making him work, right? So, they're like, oh, we'll just take a look at him later. We'll figure it out. Go eat lunch. Blah, blah, blah. So the long story of all of this is they granted him qualified immunity. But here's what's interesting. Let me go back to the top real quick because I want to show you this to you. This was written by Don Willett. That's who wrote this opinion. Circuit Judge Don Willett wrote it for this panel, Richmond, Weiner, and Willett. These are the three that heard, just like in my case, we had three justices that heard our case, me and Jim's case against Olmos Park. So this was a three-judge panel. And Don Willett is who wrote the opinion that the other two agreed to. This was the opinion of the three. Okay, we're going to give them qualified immunity. But then you go down and you read, and there's an interesting concurring opinion down here. And what's interesting about it is that there's a concurring opinion written by the guy that wrote the opinion. That's like saying, I think I look sexy. And then I take a step to my side and go, yeah, I really do look sexy. Like I'm concurring with myself. That doesn't happen very often. So that was out of the ordinary. I don't know how I missed this. I don't know how anybody missed this. But it completely confirmed what I had found through my research. For more than half a century, the Supreme Court has claimed that certain common law immunities existed when 1983 was enacted in 1871. And no evidence suggested that Congress meant to abrogate these immunities rather than incorporate them, right? This was in 1983. Of course, no evidence suggests that, because unless you go all the way back to the very first 1871 document, it looks as if every code, whether it was 42, 24, or some other code, didn't have those words in there. So when Briscoe v. LaHue was heard by the Supreme Court in 1983, they were looking at Section 1983 as it existed without those 16 words. But what if there were such evidence? Indeed, what if the Reconstruction Congress had explicitly stated right there in the original statutory text that it was nullifying all common law defenses against 1983 actions? What if? And I guess there was a professor that also uncovered this, and I love this. Wait, what? The courts have been construing the wrong version of 1983 for its entire legal life? Sure enough, he goes down here and he says, here's the Civil Rights Act of 1871, and look, here's those 16 words, right? This is what Congress passed. It's a notwithstanding clause. None of this stuff applies. You can't claim any of this stuff because it explicitly displaces common law defenses like qualified immunity, like sovereign immunity, like anything that was a custom, i.e. common law, or usage of the state, i.e. common law. Custom or usage is common law. Regulation is what regulation means. Ordinance is what ordinance means. Statute is what statute means. Law is what law means. But a custom or usage is where we get the common law. And he says, Doug Willett, so I'm not going to get back into that, but you can go look at that case. And what Doug Willett says is, look, we have no choice as the Fifth Circuit. We have to grant qualified immunity because the Supreme Court has laid out this analysis that we have to do. Have officers been put on notice that their behavior is not allowable, like that they've been on notice that you're not allowed to steal money from people, or in my case, that the officers knew that you're not supposed to point a gun and tase people who aren't breaking the law, or that officers know that you're not allowed to exercise your First and Second Amendment rights together because the courts haven't said that. Or let's go to Turner v. Driver, that, well, before Turner v. Driver, officers, how are they supposed to know you have a right to record the police? The courts haven't told him that yet. So of course they've got qualified immunity. But from now on, if you arrest someone just for recording, remember, you've already been put on notice. No more qualified immunity. And now what the justice says, so what they said in the Fifth Circuit, what Justice Willett said was, we have no choice. We cannot, as the Fifth Circuit, as a junior court, we cannot overturn the Supreme Court. Therefore, we have to say, we have to give them qualified immunity. That's just the way it is. That the only person, the only entity that can change this analysis is the Supreme Court because they've created this analysis. You look at a Roe v. Wade. It was, nobody could just say we're going to ignore Roe v. Wade because Roe v. Wade was the law of the land until the Supreme Court overturned Roe v. Wade. Now what we have to do is we have to overturn qualified immunity. And to do that, we've got to get a case to the United States Supreme Court. How are we going to do that? It just so happens that last week, the Fifth Circuit upheld qualified immunity for me and Not So Slim Jim, in our case against Olmos Park. And what I was wanting to do was complain to the Fifth Circuit, the full Fifth Circuit, en banc, instead of just a 3-judge panel. But now I'm thinking a full Fifth Circuit is just going to say exactly what, even if we win, they're still going to get qualified immunity. And if we want to challenge that, we're going to have to go to the Supreme Court. But what we really need to do is just go to the Supreme Court. So we probably need your help, because getting to the Supreme Court, and this video is not meant to, as a matter of fact, if you are going to cut and share this video, you can delete everything after this because it's going to be a beg. Okay, delete everything after this unless you want to help and share this part. But it's essentially going to be a beg. We need to get to the Supreme Court. Why? Because we need to tell the Supreme Court, you guys have been adjudicating qualified immunity on a false premise. Someone somewhere, without congressional approval, without a bill being signed into law to amend 1983 or the Civil Rights Act of 1871, changed the wording of what Congress said. It would be no different than if Governor Abbott here in Texas, if he were to take some federal law about the border and just rewrote it onto a different piece of paper and changed some words or took out some words to allow him to do something that federal law says you can't do. That would be no more law just because he changed it and printed it somewhere else than Section 1983 is, without the absence of a common law defense as Congress intended. In other words, 1983 as drafted is not the lawful version of the law. Those 16 words have been lost. We need to get them back. To do that, we need to go to the Supreme Court. If you can help, we're going to need your help. Just pay attention to this channel. I don't have a way for you to donate yet or anything, but what I want you to do is start getting the word out there that we have a way to not just sort of chip away at qualified immunity, but completely sever its head. And if it's a hydra, all of its heads. Qualified immunity can go down. I'm working with our attorneys right now to figure out what that looks like. But every single one of you that believes in liberty, that has complained about qualified immunity, who is frustrated with qualified immunity, who believes in liberty, at some point you're going to have to put skin in the game. I don't care if that skin in the game is a quarter or if it's $250,000. We don't need that much money. I don't think it costs that much to get up there. But we are going to have to hire a Supreme Court attorney, someone who is licensed to practice in the Supreme Court and will take this case in DC and argue it on our behalf and present this argument. So just kind of keep that in mind. But just know, qualified immunity does not exist. Now, it exists on paper. It exists in ink. But it's based on a fiction. It's a fiction based on a fiction, because qualified immunity is a fiction anyway. But it's based on the fiction of a law that has been changed by some scribe somewhere back in 1874. That's where all this started, back in 1874. And as the codes progressed from the first revised statutes of the United States to the second and third revised statutes of the United States to the United States Code as it is today, they never reincorporated the actual law that was passed as it relates to 1983. And that's what we've got to get fixed. That's what we got to get fixed. What I would ask some of you out there, if you've got groups that you're in, if you've got big channels, start now. Start doing fundraisers for the express purpose of, hey, when CJ and Jim say they're ready to go and here's the path forward, because I don't want to just go and say, hey, we need money. I want to say we need money and here's exactly how much we need. Here's why we need that much. Here's who we're going to pay. Here's what they're going to argue. Here's when it's going to happen. I want to be able to I don't want to just ask for money. I want to have a plan and a budget and everything laid out. So what I need y'all to start doing is start working your networks. Start doing like they do with politics, where they bundle donations to get around the $2,500 donation limits. You bundle donations from 1 million different people to get $1 million. Each person pays $1. Start collecting that money and creating a trust that eventually will go to our attorneys that are going to fight to the Supreme Court to get them to overturn themselves. That's what I need right now. Start planting those seeds in your listeners, in your viewers, in your readers, in your circles, in your Pokemon groups, whatever it is, your yoga clubs, your masonry gatherings, I don't care. But just start collecting to get this done. Now, generally it takes, from what I've heard, from beginning to Supreme Court, generally it's like $300,000 or $400,000 or something. But we've already gone through from beginning to Fifth Circuit. We just got to get to the Supreme Court. I'm thinking with and all the work's already been done. I've already compiled everything. I've even got an appeal that I've been working on, and I'm sure Brandon's been working on an appeal as well. And we're going to get together and write this all out. So it's not even like we've got to pay an attorney to do all the research and the drafting. We'll have that all done. All we need to do is hire a litigator that will go before the Supreme Court and argue our case. That's what we need from you. That's what Jim and I need. Jim and I need from you, because it just so happens that there's already a case that's most of the way through, which happens to be mine and Jim's, that we can use to make the argument that qualified immunity is a fiction and should be abolished completely, as Congress intended in 1871. I hope that helped you. I hope that you learned something from this. Take it, share it, let everyone know. If you've got a case right now that they're giving qualified immunity, you need to start arguing right this second that qualified immunity does not exist because it's based on a fictional law. That fictional law is 42 USC 1983. And it's fictional because it's missing 16 words. That's what it's missing, is those 16 words. And we've got to get them back. I'm not even going to give you my only fear because I don't want to give anybody any ideas. I have a fear of what might happen with this push, but I don't think it can happen before we're able to break qualified immunity, break its back. Sorry this is so late, and it's not exactly professional because I don't have my split screens and I'm not able to use I'm just on my laptop here. That's all I have. But I really wanted to get this out there. I wanted you to know where this is coming from, and I wanted to show you the receipts. If you're a bad cop out there, you need to be afraid. You need to be afraid because qualified immunity is not just getting chipped away at, it's going away. Chief Blanchard in Aransas Pass, your qualified immunity days are numbered. I want you so bad to claim qualified immunity as it relates to Jason Followell. Oh my gosh, please claim qualified immunity, because then there's another direct challenge to qualified immunity. So you, Chief Blanchard, can help us defeat qualified immunity by simply fighting us and claiming qualified immunity. It's up to you. It's up to you. All right, guys. Let me see. I'm going to go through some of the comments here. You can cut that right there. The rest of this is just going to be nonsense. I'm going to stay on for about 5 minutes to make this an even hour. I'm going to go look at the chat. I'm sorry I've missed a lot of you. Let's see. I'm going to start at the bottom, work my way up. That will move you up the chain. Texas Army. Let's see. I'm a former airborne infantryman, 49th Armored Division, L. Lursty. All right. What's up, Billy the Kid? My favorite, I'm an MI guy, but I was always a tactical MI guy, and I loved being with the Cav, and I loved being with armored units. And then 315 Infantry is who I was with in Fallujah, and just loved it. I always wanted to be a tactical guy. The problem was when my first enlistment was up, this is so funny. So I joined as an intel guy. Really, I just wanted to join as a Japanese linguist because I already knew Japanese, and I wanted to go back to Japan, and they made me a Spanish linguist. I ended up fighting in the drug war, which turned me off of the drug war down in South America. And by the time I was able to re-enlist, because my dumbass, and let me tell you, if you're ever thinking about the military, do not sign up for 6 years. That is the dumb, they suck you in with a 6 year because I'm going to get this giant $8,000 bonus. Back in 1994, $8,000 was a lot of money. I mean, you could almost buy a car with $8,000. And so I signed up for 6 years. Well, I realized how much I hated it. But I loved being out in the field because my first duty station was Fort Irwin. I was always in the field. And so I'm like, you know what? When I get ready to re-enlist, I'm going to re-enlist for infantry. Well, I ended up being really good at my job, and I'm not trying to, make myself look any good. But I got promoted to staff sergeant before my first enlistment was up. And so then it's time to enlist or re-enlist. And I said, okay, I want to go. I want to be an 11 Bravo. And everyone's looking at me like, what the hell's wrong with you, dude? You're free. You've got it made, man. You're intel. You don't have to live in the dirt and eat rocks. But I just loved living in the dirt and eating rocks. But MI wouldn't let me go. They have what's called a no-out call because MI was so shorthanded because it's hard to find people who are smart and have common sense. Generally in the MI field, you're either really smart, but you have no common sense, or you have a whole lot of common sense, but you're dumb as a rock. And I think that's probably why I got promoted quickly because, I'm not super smart, but I've got some common sense, and I can put pieces together. So MI wouldn't let me go. Infantry said, nope, you're a staff sergeant. We'll take you, but you have to come in as an E4. I was like, I'm going to go from an E6 to an E4. Screw that. So it was a no in call, no out call. And I just about said, that's it. I'm getting out because I can't stand this anymore. I can't do this MI job anymore. I mean, I'm surrounded by, I had some good friends too, but it's amazing how many morons are in the MI field. So what I eventually did was the USS Cole was bombed in 2000, and I decided I wanted to go into counterterrorism, and almost literally at the last minute, I decided to re-enlist, and I re-enlisted into counter intel. So I was no longer an oxymoron in military intelligence. I became a counterintelligence. So anyway, I don't know where I got off on that. Oh yeah, someone was talking about infantry. And I ended up making first sergeant in 10 years. So one of the fastest first sergeant in the field. That just doesn't happen. All right. Let's see what else. Harvey Friedberg, thank you for the super sticker there. I just saw that. This is like a fireside chat, bro. You're talking, just you talking keeps focused on the subject matter, and you kind of have a knack for it. Hey, I appreciate that, RAS. Yes, ATL Transparency News that some states have gotten rid of it. New Mexico got rid of qualified immunity. They codified getting rid of qualified immunity, and I want to try and get that in Texas as well. Six Oaks Farm says a firm I work with, I think there's extra words in there, sent this issue to the Supreme Court last year and they denied cert. Look for Holbert v. Pope. I helped write it. Okay, I'm going to write a note to myself right now. Holbert, actually, you know what I'm going to do? I'm going to show this so that I can reference it back later. Holbert v. Pope. Okay. See, and I couldn't find any. I did a super deep dive into finding case law on this, and I found it in an odd concurring opinion, and I almost didn't find it. Brandon sent it to me. Oh, Donna, thank you as well for the $20 donation. I'm going to keep all that money. I'm not going to download any of it. I'm going to wait until, like I said, we have a plan. I'm going to keep that in my, I don't know, wherever this money goes. I think I have to request the money before it gets sent to me. Let's see, asking the Institute for Justice for help. We're definitely going to ask all these people. Constitutional Freedom Fighter, thank you. Oh, the first $5, thank you. Constitutional Freedom Fighter sent $5. I appreciate you. Need shirts, hats, and bumper stickers. Born 1979, died 4/20/2024. Yeah. Institute for Justice will do it for free. You know, I think I'll call them, because if I can do it for free and not have to beg for money, I'm all for that. Hell, I mean, if I can get admitted into the Supreme Court, I'll argue it myself. CJ, I'm in. What do we need to do? Okay, I think I answered that. James Freeman equals God. Maybe Loki. I think James Freeman, if he's a god, is probably Loki. What do you think, James? The god of mischief? I think he would agree with me. And I say that lovingly. He knows that. I just talked to him tonight, as a matter of fact. I gave him this whole boring speech in like 10 minutes. What does created state doctrine, if it is a thing? We should hire Ronald McDonald. We need to get James Freeman in 5.0 and everyone tuned in. Yes, and I've already talked to James Freeman, by the way. I talked to him before I even did this podcast. Okay, I don't see any other. Who's got a big motorhome or a touring bus? Exactly. Now, who is above the Supreme Court? God. Or really, we the people, then God. We the people are above the Supreme Court. Okay, I think I got, thank you, Mr. Grisham, for sharing all this great information. Shuffletown, thank you. Thank you for listening. All right, let me go back to the bottom here now. And I saw something. Hey, Brent, thank you. Another super sticker there for $20. So again, I'm going to keep that money in there. I'm not going to touch it. If Institute for Justice takes this for free, every dollar you just gave me will be donated to the Institute of Justice if we get them to take this case on. And here's the thing, because some people might be arguing. Let's see. Six Oaks Farm said was actually started as a qualified immunity issue, but the incident was a filming the police incident, not yet recognized in the Fourth Circuit. That's why we appealed. Oh, okay, all right. So not on point, but still. What was I saying? Oh, so there might be some of you thinking, well, CJ, if you haven't raised this issue as an issue in prior appeals, haven't you surrendered that claim? Normally, yes. However, this is what I would argue. Billy the Kid, thank you for that $2, buddy. I would argue that this is a subject matter jurisdiction issue. I think qualified immunity, that the court has no subject matter jurisdiction to permit qualified immunity, because the law specifically says that a court cannot do that, because the law exempts it. The court has no subject matter jurisdiction, and subject matter jurisdiction can be argued at any stage in a case. Any stage. It can be argued at the trial court phase, and it can literally be argued the second you're walking up to the Supreme Court steps. Subject matter jurisdiction, if a court doesn't have subject matter jurisdiction, it does not have subject matter jurisdiction, period. And all we've got to do is go up there and say that the courts have erred because they've created, including you, Supreme Court, and of course they'd have to do this in a judicious way. But we would just argue, Your Honor, the lower courts had no jurisdiction, subject matter jurisdiction, to even grant qualified immunity, because the law as passed by Congress specifically said they don't get it. And so that's the new argument. So it's not like we can't bring up this new thing. There are some very narrow things that even if you don't bring up at a lower court, you can still revive at a higher appellate court. And subject matter jurisdiction is one of those things. Venue is kind of one of those things. So you've just got to do that. Oh, totally on point. We argued both issues. Okay, gotcha, Six Oaks. Thanks, man. Jim, thank you for the $3 to ourselves. And I'll definitely be contributing some money to the cause if that's the case. I'm going to pledge $1,000 just of my own money to this case if IJ doesn't pick it up. Can't post comments to some destination. Oh, that's probably telling me I can't post it to Facebook. Institute the ACLU ain't going to take it. I can tell you that right now. ACLU probably won't. Well, they might. They might. Qualified immunity is given to people they care about too. But I just don't like the ACLU. I don't want to give them. I don't want to give them the ability to say, "Oh, look what I did," when there's so much they don't do. ACLJ, that's a possibility. But I'm definitely going to go with IJ or ACLJ. Yeah, qualified immunity, man. It's just the worst thing ever. It's just the worst thing ever. It's just the dumbest thing ever. When you've got a court saying, and I'm going to end with this because I've actually got a case in the morning or a hearing in the morning that I'm going to have to get to. I'm down here in Aransas Pass right now. Yes, I know, Jim. There's so much that about our case that so many people do not know that Jim and I want so bad to talk about, but they put a gag order on it because it makes the cops look bad. You think it's corrupt what you did see? Just wait till you learn what you haven't seen. What happened before I got tased and Jim got beat up, and what happened after I got tased and Jim got beat up. You can see hints of it if you go to Pacer and download all of our filings. You can learn some of that stuff, but we're not allowed to talk about it. So I don't. I just can't wait till we're able to talk about the specifics of things. All right. Yeah, see, ACLU disagree with Heller, so screw them. Screw them. Now, they'd take a qualified immunity case if it was like a gay guy, maybe. Jim, you want to be gay for a little while so ACLU takes our case? But anyway, I've got court in the morning, so I've got to end this and take a shower and all that stuff. But thank you. Thank you, everybody. You guys take care, be safe, and be free. I'm going to get out of here.